We are living in times where two pillars of democracy, judiciary and the executive, are seemingly at loggerheads with each other. 10 days ago, the Supreme Court invoked Article 142 to declare that it's illegal and erroneous for the Tamil Nadu government or the Tamil Nadu governor to withhold assent to 10 bills passed by the Assembly. Article 142, remember, allows the Supreme Court to bypass existing laws to ensure complete justice is delivered, like it did in the Ram Janmabhoomi case. The latest Supreme Court verdict allowed 10 bills to be cleared without the signature of either the governor or the president. Not just that, the top court went one step ahead and set a deadline for the president to decide on bills. The fight back came from the Vice President Jagdeep Dhankhar. He slammed the Supreme Court for issuing orders to the president. He called Article 142A a nuclear missile that is available 24/7 to the judiciary. He even asked, how are judges immune to legal action, in a veiled reference to the sacks full of cash found at a High Court judge's outhouse. Remember, here on the Newshour, I got you the visuals of firemen exclaiming, Gandhi ji jal rahe hain. Anyway, the retort from the judicial corridors came from senior lawyer Kapil Sibal. Watch the war of words.
We cannot have a situation where you direct President of India. And on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). Article 142 has become a nuclear missile against democratic forces, available to judiciary 24/7.
कुछ सरकार के लोगों को जुडिशरी के निर्णय पसंद नहीं आते, तो फिर वो आरोप लगाना शुरू कर देते हैं कि ये हद से बाहर है। और एक कॉन्स्टिट्यूशनल फंक्शनरी को ऐसी बात कहनी मैं समझता हूं उचित नहीं है। आपने कह दिया कि आर्टिकल 142 इज न्यूक्लियर फिसाइल मटेरियल, न्यूक्लियर मिसाइल। आपको मालूम है कि आर्टिकल 142 के द्वारा सुप्रीम कोर्ट को संविधान ने यह हक दिया है।
You're watching the News Hour at 9, debate number 2 on Times Now, Super Prime Time.
Joining the debate, Dr. Anand Ranganathan is joined by Jay Dehadrai, advocate on record in the Supreme Court, Ranjit Kumar, former Solicitor General, joining the debate. Also, Sanjay Hegde, senior advocate, Aman Lekhi, former ASG and senior advocate in the Supreme Court. Ranjit Kumarji, I want to ask you, the Vice President has raised a debate. I want to ask you, can anybody set a deadline for the president? Because in India, we have a situation where all judges, as do all ministers, everybody, even bureaucrats, serve at the pleasure of the president. Can they set a deadline for the president? Or is the view that says that, judiciary will and has the right to comment on everything and decide on everything? Where do you stand on this debate?
Well, first of all, these statements made by Honorable the Vice President during the talk to the interns who had come to the Rajya Sabha were in the context of, according to me, the Tamil Nadu governor judgment. And in that what he was saying was that the issue of timelines for the president was not present before the court. What was present before the court was entirely the role of the governor. The issue with reference to the president did not come up. It has been still made a part of the judgment, which ought not to have been unless the President of India, through the Union of India, had been put to notice that we will be discussing your powers as well. That's how I'll put it.
So, Aman Lekhi, Aman Lekhi, when the question of the powers of the president was not before the Supreme Court, could it have adjudicated this entire issue and passed a judgment that gives deadlines to the president and includes action of the president along with the issue of the governor and his role in the matter that was being adjudicated?
Yes, it could have. As far as the facts are concerned, the facts in the law, by their very nature, would also incorporate the issue involving the president, because what was under interpretation was 200 of the Constitution, and 200 of the Constitution has to be read along with 201 in the peculiar circumstances in which the court is seized. Please understand, all that the court has done is, the court has not rewritten the constitutional provisions, nor has it violated the principle of judicial restraint, which is the first criticism you make about judicial activism. It's also not a case where political ideology or personal opinions have in some way replaced constitutional provisions. What the Supreme Court has done is the Supreme Court has followed interpretative fidelity and has in some way, insofar as the judgment is concerned, enunciated the law as it exists and as is understood. All that the court has done is that because the bills were not returned back and were actually retained by the governor, has mandated that the period of time which should be available should be reasonable. And as far as this principle is concerned, the principle is absolutely basic, because merely because discretion is available doesn't necessarily mean that it should be unrestrained, and there be absolutely no guidelines for the purposes of exercise of it, because that will violate a fundamental principle of law, and that is reasonableness. What the court has actually done is it has revisited the law to the extent it said that the governor's discretion is not reviewable, because considering the action of the governor in this case and other instances which were available, it found that the assumption that high constitutional holders would actually exercise their power in a manner constitutional norms mandate has been shown to have been an expectation that has not been realized, and therefore law has to intervene to set out the rules which has to in some way guide the discretion. In so doing, the court has discharged a judicial function.
The discretion is different from ordering. And this is an order of the Supreme Court and Jai Dehad Rai. I want to ask you, this decision actually effectively makes the judiciary the final authority, sidelining the president completely. Is that a precedent that will allow states to seek a writ of mandamus if the president fails to act?
Is that question for me?
Navika ji, good evening. As far as I'm concerned,
that's what Jay. I'm coming to you, Sanjay Hegde.
Is completely unconstitutional. Yeah, this judgment is completely unconstitutional, and I think it misinterprets what Articles 200, 201, and in fact even Article 143 have been completely misinterpreted in this judgment. I am certain that this will go before a larger 5-judge bench, a constitutional bench for reconsideration. This is insofar as my view is concerned. In fact, what this judgment has done, if I can just take 20 seconds, Navika ji, and if I could just point out what I think is wrong with this judgment, entirely wrong, is that it basically infuses new meaning, that the honorable bench has come up with its own meaning and timelines and has infused it into articles of the Constitution, which according to me is completely unacceptable. In this situation, as you rightly pointed out, certain directions have also been made to the President of India. A timeline has been imposed. In fact, even the advisory jurisdiction, which is Article 143, which is in fact advisory, it is optional. It doesn't mean it is binding upon the President of India at all. Now, basically, it has been said that once a bill is sent from the governor to the President for reconsideration, he must compulsorily, sort of use the advisory jurisdiction that is available under 143 and then comply with it. So I think this is
I really don't want to get into too much of the legalese, because there are basic questions that people of India want to ask. And Sanjay Hegde, my question to you is that, is the judiciary the last step which will decide everything, and who will be accountable within the judiciary? Because we've just seen a case of Gandhiji burning in an outhouse of a judge. The matter was under investigation. A 3-member committee was set up. Nobody's heard anything since then. Now, if the judiciary is setting norms for the president Parliament of India, shouldn't it set some norms for its own self and respond to the larger public questions that arise?
Okay, you are going after the man and not the message. Firstly, let me answer. What is the message?
No. Sanjay Hegde, I'm not going after any man. I'm not going after any man. Okay, I'm asking you what is the question on the streets by the people? Because all institutions are here to serve the people of India.
Okay. To the people of India, I first say that all that the Supreme Court has done is to interpret the law as stated in the Constitution. The Constitution says that the governor has to decide on a bill as expeditiously as possible or as soon as possible. The phrase as soon as possible, the Supreme Court has interpreted. It has said, okay, fine, do it. It shouldn't take more than 3 months. Secondly, it has not given any specific direction to the president that you will sign this particular bill within the next 7 days, within the next 15 days. It has said that whatever we have said in the case of the governor will also apply to the president. And why did the Supreme Court say it? Think of a time where the Prime Minister and the President don't see eye to eye. Can a President do to the Prime Minister what the current Governor of Tamil Nadu has done to the elected Chief Minister of Tamil Nadu? We are a parliamentary democracy. We are not a presidential form of democracy.
Okay.
That is why the Supreme Court...
So that means we are a parliamentary democracy. Anand Ranganathan, for a layperson, what does that mean? That means that courts can overrule whoever, they think at that point in time, depending on, the narrative that is going around, they can adjudicate on that. Isn't that, in simple common man language, what we are hearing here?
Well, according to a layman, the courts can overrule anything, but the parliament can overrule any decision of the court unless it affects the basic structure of the constitution. That is the layman's reading. But I want, as a layman, what does a layman see what the Supreme Court has been doing in the last week and what the Vice President has said? He talked of two issues, and I very briefly, within 30 seconds, want to talk of exactly those two issues. Number one, the common man sees when 50 million cases are pending, 80,000 are pending in the Supreme Court, and the Supreme Court hasn't set any deadlines to solve those cases. Here is the Supreme Court setting a deadline for the President. Number one, that is what the common man is seeing. Other than the fact the Supreme Court says the President should take the advice of the Supreme Court in adjudicating, and she's lost her pocket power. Now, the second thing I want to ask Mr. Lekhi, the eminent lawyer, there are many eminent lawyers here, but specific question to him. In the event that a forensic and criminal investigation is to be conducted in India, who is best placed to conduct it? Judge or the police? Simple question, Mr. Lekhi.
Aman Lekhi. Aman Lekhi, common man question.
I don't know what this rant is about. We are jumping from the topic which you are discussing to something which is totally unrelated. Now we can all ask questions in the abstract and then contemplate answers. Point is, we are not here to discuss the sake of discussing and making a point. But because this question is put to me, I'll answer. As far as the forensics are concerned, there will be multiple agencies. The agencies will include the police, that is the investigating agency, but that will not be the final agency because the matter will eventually come to the court and according to legal principles, it will be applied and decided. Even as far as investigating agencies are concerned, the role will be divided among several of those particular entities and all of them would collectively look into it. But that issue is not what we are discussing today. The question we are discussing today is, did the Supreme Court exceed what it was, the limits within it has to act? And my take is, it has not.
It has
not. And I'll explain why.
Okay, deadlines for the President can be set by the Supreme Court. But deadlines for the Supreme Court, well, that's an open question. Dare we not say anything? Contempt of court hangs as a sword upon us. We leave it at that. Thank you very much to all my esteemed panelists for joining me on this debate. Good night, viewers. Thank you for joining me. Have a safe weekend. I'll see you back on Monday.